Hey there, I'm the MadCatster. Am I glad to see you here? Well, we haven't heard the last of the TikTok psychic. After judgment was entered in favor of the professor, the TikTok psychic, of course, filed a motion to reconsider, basically asking the court to reconsider its judgment, finding her liable for the defamation. So let's take a look at how the professor has responded to the TikTok psychic's motions. And then the TikTok psychic, of course, had to fire back after that. We're going to breeze through it. You know me, I've got the deets and all the receipts, so buckle up and let's go. Hey guys, I'm here with Clarice. Again, Clarice is here. And Sybil's upstairs. I don't know what's with Sybil. She doesn't come downstairs anymore. We have now hit 55,000 subscribers, so we're 5,000 ahead of where we were just a few weeks ago, which is excellent. Thank you guys so much for all of your support. And if you're not subscribed, please like and subscribe. We would really appreciate it. I've got some people to thank. We've got some new Patreon patrons. We've got some things that came to us from the Amazon wishlist, so stay tuned for that at the end of the video. But now let's talk about this ongoing nonsense with the TikTok psychic and the professor. So as we had discussed in my last video, the TikTok psychic filed this crazy motion for the court to reconsider the judgment, giving all this rehashed nonsense about why she believes that she's being persecuted for her religious beliefs and etc etc. Well, of course, the professor has had to respond. The professor had ordered a transcript because Ashley Gillard had made reference to the transcript in her motions, and after they got the transcript, they went and prepared their oppositions to her ridiculous motions. We're going to look at those quickly, and we're just going to briefly talk about how Ashley Gillard has responded to those motions. We're not going to go through all of her stuff because she just rehashes the same crap over and over again. So stay with me and let's breeze through what's going on right now in the court. So you see here we've got plaintiff's response to defendant's motion to alter or amend judgment. And basically that's what Ashley Gillard called it, although it's really a motion for reconsideration, asking the court to reconsider its decisions. So, introduction. Defendant Ashley Gillard seeks reconsideration of the court's order, granting partial summary judgment in favor of plaintiff Rebecca Schofield and allowing plaintiff to seek punitive damages. Ms. Gillard's arguments are both meritless and a bald attempt to relitigate decided issues. She thus falls well short of the high burden for reconsideration. The court should deny her motion. I'm not going to rehash this background because we've gone over it a million times. If you want to hear more about the background in this case, go back to my video 2 videos ago, and I go over it all again there. The legal standard for the motion is there are 4 basic grounds upon which a Rule 59E motion may be granted. Number 1, to correct manifest errors of law or fact upon which the judgment rests. 2, to present newly discovered or previously unavailable evidence. 3, to prevent manifest injustice. Or 4, if the amendment is justified by an intervening change in controlling law. A manifest injustice is an error in the trial court that is direct, obvious, and observable. A manifest error of fact or law must be one that is plain and indisputable, and that amounts to a complete disregard of the controlling law or the credible evidence in the record. A Rule 59E motion may not be used to relitigate old matters or to raise arguments or present evidence that could have been raised prior to the entry of judgment. So in other words, if you've got new evidence that suddenly came to light that was not available before and no one was aware of, then that would be one reason for the court to reconsider. But in this case, Ashley Gillard is basically just rehashing all the evidence that was already presented. She's basically saying, I didn't like your decision, Judge, reconsider it, and I'm going to throw the same arguments and the same crap at you, and there's nothing different. The moving party bears the burden of establishing grounds for relief under 59E. A party seeking reconsideration must show more than a disagreement with the court's decision, and recapitulation of the cases and arguments considered by the court before rendering its original decision fails to carry the moving party's burden. And so they're saying basically that she hasn't argued anything new. She's just basically rehashing the same old evidence that the court considered when it rendered judgment. Argument. Ms. Gillard appears to argue that reconsideration is warranted either to correct a manifest error of law or to prevent a manifest injustice. Although Ms. Gillard's arguments are numerous and often overlapping, they appear to boil down to 6 points. Number 1, the court erred in finding Ms. Gillard liable for defamation because Professor Schofield failed to establish that Ms. Gillard's statements were false, or relatedly because Ms. Gillard relied on her spiritual investigation. 2, the court lacked jurisdiction to find Ms. Gillard liable for defamation because only a criminal court could determine whether Professor Schofield participated in the 4 deaths. The court lacked jurisdiction. Number 3, the court lacked jurisdiction to find Ms. Gillard liable for defamation because Professor Schofield is not entitled to more than $75,000 in damages. Number 4, the court violated Ms. Gillard's right to a fair tribunal. Number 5, the court erred in allowing Professor Schofield to seek punitive damages because Ms. Gillard did not act with a bad state of mind. 6, the court erred in finding Ms. Gillard liable for defamation because Ms. Gillard's false statements were privileged. Ms. Gillard's arguments fail under any standard, let alone the high burden needed to obtain relief under Rule 59E. The court should deny Ms. Gillard's motion. And goes on to say that, her motion is procedurally improper because the court has not entered final judgment. I made a note in the description after I did my last video. I was wrong. Someone had pointed that out to me. Even though the court has found her liable for the defamation, because the damages issue has not been litigated yet, it's not really a final judgment, and so she can't appeal. Ashley Gillard can't appeal until final judgment is entered, which will be after the jury decides damages. Then she can ask for the reconsideration, and then she can also decide to file an appeal. The court did not commit a manifest error by finding Ms. Gillard liable for defamation. Ms. Gillard offers meandering complaints about the court's decision that she is liable for defamation, but her argument appears to be some combination of the following points. 1, Professor Schofield did not prove the falsity of Ms. Gillard's statements. 2, Ms. Gillard's statements were properly based on her spiritual research. And 3, Professor Schofield has not established damages. In other words, Ms. Gillard's motion is simply a disagreement with the court's conclusion that Professor Schofield is entitled to summary judgment under Rule 56. Such a disagreement is a matter for appeal, not reconsideration. So once final judgment is entered, she can go ahead and appeal it, but basically they're arguing that that's the proper avenue of redress for Ashley Gillard, not a motion for reconsideration. The court should thus deny Ashley Gillard's motion. And I'm not going to read the rest of this. C, the court does not lack jurisdiction to adjudicate a defamation claim. Ms. Gillard next complains that the court cannot use the civil tribunal process to decide Schofield innocent or guilty of the crime, nor is it in this court's authority to rule Mr. Koberger, the guy who was actually arrested by the police as a suspect and was charged, and I think he's still awaiting trial, guilty of the crime. Ms. Gillard's argument again misstates or misunderstands the court's decision. As is within its authority, the court applied the summary judgment standard under the federal rule of civil procedure, Rule 56, finding that Professor Schofield submitted sufficient evidence to carry her burden of establishing that Ms. Gillard's statements were defamatory and that Ms. Gillard failed to submit sufficient evidence to create a genuine issue of material fact. The court did precisely what it's supposed to do under the applicable civil rule. Ms. Gillard's motion should thus be denied. D, the court has properly exercised diversity jurisdiction over this case. Ashley Gillard is again arguing that the court doesn't have jurisdiction over her, and this was already argued early in the case. She made this argument and it was shot down. So what she's arguing here is that she's saying correctly that the court, in order for the federal court to have jurisdiction over the case, damages have to be in excess of $75,000. And Ashley Gillard is trying to say that there aren't going to be enough damages to hit that threshold. I seriously doubt that, but let's see what they have to say. The court already meticulously addressed this issue back in November 2023, and Ms. Gillard offers nothing new to contradict the court's earlier reasoning. As the court previously explained in a diversity case originally filed in federal court, the sum claimed in the complaint controls. If the claim is apparently made in good faith, it must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal. So in other words, it would have to be very obvious that there's no way she was going to be able to prove $75,000 worth of damages. But this case is so broad that there's no way that you can make a determination. And so the court is saying that they take it on good faith that the plaintiff filed the complaint expecting the damages would exceed the threshold. The legal certainty test permits a district court to dismiss the case for lack of jurisdiction only if it is obvious on the face of the complaint that the suit cannot involve the necessary amount. This standard makes it very difficult to secure a dismissal of a case on the ground that it does not appear to satisfy the jurisdictional amount requirement. Here, Ms. Gillard put Professor Schofield's career on the line by stating that she had an inappropriate affair with a student and participated in the deaths of 4 students. Professor Schofield also suffered severe emotional distress, understandably, because if you guys have been following this case, oh my God, Ashley Gillard just doesn't quit. She's like the Energizer Bunny. She just doesn't know when it's in her best interest to back down. Professor Schofield's request for more than $75,000 in damages is well justified. Ms. Gillard's motion should be denied. The court has not violated Ms. Gillard's right to a fair tribunal. Ms. Gillard asserts that the court has robbed Ms. Gillard of her right to an impartial tribunal, impeded upon Gillard's right to an impartial tribunal, and demonstrated personal bias towards Ms. Gillard and her spiritual beliefs. The basis for Ms. Gillard's attacks is that the court granted Professor Schofield's motion for summary judgment. Disagreement with the court's decision is grounds for an appeal, not an attack on the court's impartiality. By necessity, absent settlement, every case is a winner and a loser. Further, Ms. Gillard's myopic focus on the court's most recent ruling ignores that she had cited a case that was more recent than when this was filed. Further, Ms. Gillard's myopic focus on the court's most recent ruling ignores that the broader record shows that the court has been more than fair to Ms. Gillard. The court, for example, set aside Ms. Gillard's default over Professor Schofield's objection, denied Professor Schofield's request for attorney's fees incurred to challenge Ms. Gillard's baseless counterclaims, denied Professor Schofield's motion for sanctions, and sua sponte granted Ms. Gillard additional time to answer Professor Schofield's request for admissions over Professor Schofield's objection, and after Professor Schofield incurred the expense of briefing a summary judgment motion based on those admissions. There is simply no evidence of bias here. The court should deny Ms. Gillard's motion. It's so true. I mean, how dare she say that this court has been biased against her when the court has gone above and beyond, in my opinion, to give her leeway to comply with the court's orders, even though, in my opinion, early on when she was mocking the entire lawsuit, she, I believe, was fully aware, in my opinion, of when the deadlines were and just ignored them. But yet the court still gave her a second chance to fix it. The court did not manifestly err in finding that Professor Schofield could seek punitive damages at trial. Ms. Gillard's complaints about the court's decision to allow Professor Schofield to seek punitive damages is nothing more than a disagreement with the court's decision, and thus Ms. Gillard's motion should be denied. And again, these are all issues that she can appeal after final judgment is entered after the damages trial. Ms. Gillard's defamatory statements were not privileged. Ms. Gillard claims that her defamatory statements were privileged because they were made to law enforcement or as part of a judicial proceeding. Ms. Gillard's assertions are incorrect. As the court observed, Ms. Gillard made numerous statements on TikTok and YouTube. Those online posts were not made to law enforcement or in a court proceeding. Ms. Gillard's statements were thus not privileged. Her motion should be denied. In conclusion, Ms. Gillard's motion to alter or amend judgment is procedurally improper and fails to meet the high burden for reconsideration. The court should deny the motion. And I agree. In my opinion, I think the court will absolutely deny her motion, and will also deny, and we'll talk about this in a second, the motion for the judge to be changed out. Because remember, we discussed in the last video that it was a magistrate judge who took over the case, and both parties had to give consent. And in writing, Ashley Gillard gave her consent for a magistrate judge instead of the regular district court judge to take over handling the case. And of course, this is because of caseload, etc. So things get delegated out. And Ashley Gillard, in writing, gave her consent. And so it's a little too little, it's a little too late, as Pat Benatar once sang. Now let's take a look at, briefly, how the professor responded to the motion for the judge to be changed out. And for some reason, Ashley Gillard filed a second motion for the case to be reassigned to a regular district court judge. I don't know why. And we'll see here that the professor argues that basically both of the motions are the same. And here you see the opposition to the defendant's second motion. There's no need to read the first opposition. We'll just handle this because the second one is the last one that was filed. Opposition to defendant's second motion for reassignment to a U.S. district judge. On July 8th, 2024, the court docketed what is called defendant Ashley Gillard's second motion to reassign. It's unclear to plaintiff Rebecca Schofield whether Ms. Gillard intended to file a second motion or if she merely mailed an original of her first motion to the court, as both motions appear to be identical, including the date of Ms. Gillard's signature. To the extent Ms. Gillard did not intend to file a second motion, Professor Schofield incorporates in full her opposition to defendant's motion for reassignment to U.S. District Judge dated July 2nd, 2024. Whether it is Ms. Gillard's first or second motion, the court should deny Ms. Gillard's request to reassign the matter to a United States District Judge. And here's the first opposition to defendant's motion for reassignment to a U.S. District Judge. After more than 18 months of litigation before United States Magistrate Judge Raymond Patrico, defendant Ashley Gillard moves to reassign this case to a United States District Judge. Ms. Gillard must support her request with a showing of extraordinary circumstances. She failed to do so. Her motion offers no justification for reassignment. The motion should thus be denied. And as we saw, and I showed you, she had signed a written consent that the case could be delegated from a U.S. District Court judge to a magistrate judge. And that's exactly what happened, and that's who's been handling this case since that point. It's way too late. So there you have it, folks. And I'm not going to go into what Ashley Gillard, she filed replies to these oppositions, but it's the same nonsense that she regurgitates over and over again. I don't think we need to hash it out anymore. Like I said, go to my second to last video where I talk more in depth about her motion for the reconsideration, and I go over all the background again there, but there's no need to go over it. Of course, she rebuts the arguments made by the professor's attorney, and in my opinion, they're not effective or relevant arguments. And so my opinion is the court is going to deny both of Ashley Gillard's motions, and we will finally move on, hopefully, towards the jury trial to decide the damages. I will keep you up to date. Let me know what you think down below in the comments. What do you think about the ongoing reluctance of Ashley Gillard just to back off? If she had just backed off back in the beginning, we wouldn't have any of this going on. She wouldn't have a judgment against her. But she was stubborn, and this is what happens. And she represented herself, which in this kind of a complex federal case, I certainly would not want to be representing myself if I were her. But I don't know. She, like many misguided people before her, figured she could hack it, and she just made a mess of it, and she's now paying the price for that. But let me know what you think down below. Now, so I want to thank very much Ashley M for sending us a bunch of stuff from the Amazon wish list. We appreciate so much, you guys, the stuff that you guys send. And she sent us one of the nice, warm, round beds that the cats absolutely love. She also sent us a whole bunch of treats. She sent us several containers of the Temptations cat treats, which the cats absolutely love, and we go through a ton of those. The treats and the food and litter are like the three things that we just blow through on a regular basis. And so she sent us a bunch of treats, and she sent a nice note saying that she hoped I felt better. And actually, yes, I am feeling so much better. And anyone else who's wondering, I've been doing great. I don't get it. I don't understand what's going on. The blood tests I had done when I came back from being in the hospital showed that I am indeed allergic to cats, and I'm highly allergic to cats. And I'm also somewhat allergic to dust mites. Those are the only two things that come up in all of the stuff they tested me for that I have an allergy to. I've been around the cats. I do wear a respirator, like if I have to brush them, or if I'm cleaning, or if I'm doing the litter boxes, I wear a small respirator to do that so that I don't inhale anything. But I've been fine. I'm being careful. I'm on medication. I'm starting my treatment to build up a resistance to the cat dander, and there's drops that I'll be taking every day, and it'll go on probably for a couple of years, they think, before I'll build up enough of an immunity to it, or enough of a resistance to it that I won't have to worry, hopefully, about a big flare-up like that again. But I knock on wood, I've been doing fine. So Ashley, thank you so much for all the stuff you sent us. Thank you everyone who sent us stuff on the Amazon wishlist. Also, thank you so much to all of our Patreon patrons and our channel members. Thank you for your continued support every month. That helps to defray the vet bill, which we pay twice a month, every month. But I really appreciate you guys so much. Thank you so much for all of your support. Let's keep growing. I've got another video coming. But in the interim, Take care of yourselves, love one another, and I'll see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.